Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of the Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
Thanks, Brad. As a business and healthcare firm, we meet a lot of interesting people and learn some amazing stories. In today's episode, we're going to talk about the fast and loose world of healthcare transactions and why details matter.
Today, we have a special guest joining us to help tell this story. Michael?
Well, before I introduce our guests, I saw a fascinating article recently in The Atlantic. Apparently, in Japan, people are hiring actors to play a role as their friends, their family, and even as their spouse. I guess the story goes they go places with these actors and, of course, capture their full and rich life with their friends and family on social media.
You know, in Texas, they call that all hat, no cattle. All right. Well, anyway, before we get started on our story today, let's introduce our guest now.
Yes, after kind of leading with a sad story of the loneliness that's happening in Japan, we'll transition to introduce our partner, Jay Reyero. Jay is in our Dallas office. He's worked with us for at least 12 years. Over that, he actually started with us while we were in law school, and we were somehow able not to let go of him through that journey up to being our partner. Jay graduated from UT undergrad, went to SMU Law School, but like me, his loyalty lies with the Longhorns. And he's married to his wife, Katie, who I believe he started dating in the 8th grade, and has 3 daughters, has run a couple of marathons, and is often referred at our office as the smartest person at ByrdAdatto. Jay, thanks for being here today.
Of course. Very happy to be here and happy to be part of this episode.
So, Brad and Jay, you guys have, I don't know, maybe a micro niche at our firm. We're pretty specialized as it is, but you guys are known as the use quotes regulatory attorneys here at ByrdAdatto. Whenever there are federal or state healthcare regulatory issues, all the attorneys come running to you to help lead us through that project.
Yeah, and many times Brad and I both end up working together. I mean, with these complex or even potentially complex regulatory matters, we try to get the other one involved right away. It's good to have another set of eyes, another set of ears to kind of make sure we cover everything and we're not missing anything. But also, these things are difficult. It's not always black and white. It has some interpretations, and so it's good to have that second opinion throughout the process.
And so, because regulatory matters end up sometimes with orange jumpsuits, you might imagine that you guys have a lot of good stories. There's one good story that jumps to my mind because I got to play a small part in it, and actually had to become involved in that matter towards the end.
Yeah, if I remember correctly, you were there at the beginning and the end, and you kind of luckily escaped everything in between.
Barely, sometimes.
Yeah, and I think, going back what Jay had said earlier, in this particular experience, I was brought in early on, and like everything that happens in the healthcare field, having a second set of eyes is so important. It's hard to be a solo healthcare attorney because of that, because you're on an island. In this particular case, I knew early on I needed to bring Jay in to help in a lot of moving pieces.
So, with that, let's hear today's story.
So this story starts off kind of like a bad joke. Two business entrepreneurs walk into a conference room with these big ideas of vision and lots of money. Both had backgrounds in the healthcare industry. One was working as an accountant, the other one as an RN. Neither one had ever started a business, but watched as their employees and their friends were making a ton of money, and they're like, okay, we can do this too, which is often the case with entrepreneurs. I think, it's great. In the positive way, they have that entrepreneurial spirit that they can take on anything. In a negative way, they don't know what they don't know.
I remember that first meeting well. To say it kindly, they had a lot of charisma. I remember afterwards telling Brad and Jay that we might need to start offering bottle service for this particular segment.
Yeah, they had a lot of charisma. There's no doubt about that, which is going to play later nicely for these gentlemen. But I remember one specific question they asked that I had to answer. It was, why are we required to have lab equipment on site to have an official lab?
And this, everyone, is what we call a red flag moment.
Yeah, it's a sign you're creating shell companies, which kind of is a problem when you're trying to be compliant.
Yeah, and this running theme with this clients, you're going to hear a lot, and you'll hear the form didn't always equal the substance, meaning that they would tell us something to document, and we prepare it that way, and yet it didn't always reflect the reality of how they're actually operating their entities.
So, Brad, what were they trying to do?
What weren't they trying to do? They were all over the place, but their primary focus was to create physician-owned laboratories.
And Jay, at what point in this process were you brought in?
It was very early on. I remember the first email I got from Brad. It was one that he forwarded from the clients after one of his meetings. The clients had gotten their hands on a laboratory offering document and started editing it. And this isn't exactly uncommon. I mean, we encounter a lot of people who see or hear about business plans or arrangements that other people are doing, and they think, oh, I'll just take their documents, I'll change the names, and nothing else will go wrong. It'll be completely compliant.
And so, vocabulary word for the day, the term offering document, in a nutshell, there are some securities laws that are in play, but this is the legal documents when you're in a private business and you're bringing in individual investors. It's the package of documents that go with that.
Right. And this was an offering that they were going to be doing to start a toxicology laboratory with equipment, people.
Yes, a legitimate toxicology laboratory. And in order to get it up and running, they were going to be raising money by offering ownership to various physician investors, exclusively located in the same state. And this process is sometimes called an intra-state offering. But to be clear, it is a private offering, and it triggers security laws, as Michael said. So there are rules that must be followed.
Yeah, and so over time, they actually were making more money and being successful. And these clients wanted to do other deals. And in doing so, they said, why don't we start a management company, and we could be a provider of certain management services, and we could oversee other ancillary companies like other labs and other pharmacies. And again, they went back to the physician investors to seek them out and saying, hey, come join us. But during this time when we would meet with them, and it felt like often they would start talking about their matching sports cars they have and how they are partying with all these docs and going to clubs and going to Vegas. I mean, Michael, how many times we get invited to Vegas? A ton, right?
Yes.
And all this other entertainment just to wow these physicians on this great new company they were building, and they were the guys to do it.
So, Jay, how did that project go?
Well, first, with management companies in healthcare, several regulatory issues that are involved that can create significant liability if you don't follow the rules precisely. And this is especially the case when you're involving physician investors. And so as I started discussing with them these particular rules, just red flag after red flag started popping up.
Name a few.
Well, so whenever a client wants to start a management company, obviously the first question I have is, okay, what services will you be providing? It's a fairly simple question, right, to answer, and one critical for us to be able to draft the actual management services contract that they're going to be using with their customers. And Brad, what is the one answer to this question that we get that creates the biggest red flag?
And Jay, it's not so much an answer as it is a question. Well, Jay, Brad, what services should we provide?
Exactly. So imagine this. How can you plan to start a bona fide management company if you don't even know what it's going to do?
Well, could they have not just known what their business plan was quite yet and wanted to know what other management companies were doing?
Sure, that's definitely a possibility, and sometimes that is the case with certain clients.
Yeah, but Jay, I think you and I both thought that in this case, based on how other conversations we had and what was going on, they were just looking to put something on paper, and not so much how their business would actually operate.
True. And this was then confirmed by the second red flag that popped up. So remember, this was going to be another offering. And so I started asking questions about the money they were going to raise. How would it be used? What's the purpose? And one of the resources you would expect with any management company that they would need first is going to be personnel to actually, be able to perform services for those customers. And yet it was apparent through my conversations that this wasn't the consideration.
So going back earlier, this sounds like a shell company, like we talked about.
Yeah, and as Jay said earlier, that's a problem when you're trying to be compliant. On top of that, you added the physician investor piece, and we started talking through their plan and asked a series of questions that raised the third and, unfortunately, the biggest red flag.
And what was that?
Can we have a trial period before we offer physicians ownership opportunity? Or how often do we adjust the ownership percentage? Or can we create a sub-management company and just group the physicians separately depending on how good they're doing?
Yeah, or my favorite, how can we kick a physician out if they're not producing?
And, and Jay, you and I often get these questions when people are trying to figure out what they can and can't do. So pushing those boundaries or getting those questions to us, simply hearing that by itself doesn't always create a red flag, especially when they're trying to work with other physicians and create vehicles which they can legally and legitimately invest in. And most of the time with our clients, once they start hearing the restrictions and laws, they stop asking the same question over and over.
Yeah, and as Brad and I push back on all these compliance issues that were very significant we were raising, they just continued to come up with different questions and different scenarios. Well, what if we did this? Or what about this? Or what would you say about this? And at the end of the day, they never addressed the fundamental issue of compliance that we had identified at the very beginning. And in fact, we kept talking and going circle in circle that finally they started getting aggravated with us because we'd always remind them that when these physicians were buying in, it had to be at fair market value. And Brad and I probably said fair market value 1,500 times, it seemed like. And at one point, they would ask a question, and before we would even answer, they would say, "And don't tell me about fair market value." They knew we were going to say it because it was just the same issue over and over and over.
And so, like all good clients, we're trying to counsel them how to put together a deal legitimately. And after round and rounds of going with this particular client, when at one point they said, "So, how can I legally give kickbacks?" And that was it. That was the last straw for us. We immediately put this project in hold because we felt confident. It wasn't that they didn't understand potential healthcare regulatory issues that they were facing. They just had no intention of following any of the guidance that we were creating, and especially because we're trying to make a legitimate management company. They just wanted to have something on paper that they could check the box, tell everyone it's perfect, it's good to go, but their true operations and then their intent, they weren't going to follow it. And so clearly, for many different reasons, we can't represent a client who's not going to follow our counsel. They're going to jeopardize their investors, which jeopardizes the entire arrangement, which then also obviously impacts our firm's reputation.
And we'll get a little bit more into this later, but at the end of the day, if in a healthcare regulatory context, if you are paying physicians for referrals, that's a big problem. And that's what all these questions ultimately related to, was the final question they asked Brad, which was, how can I legally pay for referrals? And so this is the point where I got involved again. I remember thinking it's probably time to move on when you feel like you need to take a shower after every meeting. And so we agreed that we had no choice but to terminate our representation. And so I was the one that delivered the message. So this was a memorable story. Throughout the story, the common theme was that our client was, asking us how to structure documents in a compliant manner, but really they wanted documents that were, quote, legal, but they also wanted to pay for referrals. And so we'll get a little bit more into this on the other side of the break as to what the actual legal issues are.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back. Brad and Jay, you were involved in a crazy client experience. One that ultimately, as we talked about, resulted in us having to terminate our representation with the clients. We had a laboratory with no equipment. We had a management company with no people. We talked about this growing sense that we had that our clients were not interested in actually doing things compliantly. Red flags were popping up with the constant, what if we did this way, or what if we did it that way? And we had already talked about it time and time again. I felt like a broken record because y'all would say the same thing in a different way as to how things needed to be done.
Yeah, and healthcare is highly regulated. So anytime you have a financial relationship with a physician, you have to understand what healthcare regulations you're triggering. And whether it's federal laws or state laws, each one's unique, and it has its own set of rules on how to be compliant, so it can be difficult sometimes. The laws involved in our clients' deals focused on ensuring that physician investors were not simply becoming owners or becoming involved just to reward them or pay them for their referrals or to capture a stream of referrals. So the one thing to keep in mind, though, is healthcare laws do not prevent physicians from having legitimate business arrangements, but they do prevent physicians from being paid for their referrals.
Yeah, and let's be clear. I mean, the entire reason you should ever want to work with a healthcare attorney is so you can develop a legal and compliant model. So if you're only working with that healthcare attorney to get their paper or their documents or just use their name and goodwill in the community, but you're not actually going to follow their guidance, that is a recipe for disaster. As you're only setting yourself up, you're setting your investors up for, unfortunately, potential civil and criminal fines, loss of medical or their licenses in general, and unfortunately, as Michael said, potential orange suits down the road.
And so the idea of a management company, that's kind of like the duct tape for healthcare. It's used for so many different reasons. And when it's used for the types of things we're talking about today, where federal laws and state laws on paying for referrals are involved, the red flags really matter. So let's talk about, what are the concerns with a management company kind of in the context of the things we're talking about today?
Yeah, so with the management company, the main concern is the fact that physicians are being asked to invest in a company where there really isn't a plan to run the company as a legitimate business. Again, how can a management company perform management services without people? By itself, this may not be a big deal, right? But this management company planned to do business with providers to whom these same physicians are driving business. And so these direct, indirect referral relationships, they immediately create the possibility and the appearance that these physicians are simply being paid in some way for their referrals. So you have to combat that perception. You have to demonstrate that, no, this is a legitimate business operation that's being conducted independent of any referral relationships. And this becomes a difficult argument to make when in reality, no services are being provided, no people are there, and yet we see money being transferred to this management company from these ancillary providers.
So Jay, is this unique to management services agreements?
Not at all. So in a lot of the media releases regarding healthcare kickbacks that you'll see from the OIG or the DOJ, you'll see claims of people paying kickbacks using what they call sham medical director agreements or sham consulting agreements. And these agreements can be perfectly compliant. They're used in the industry all the time. And they're probably, the ones involved in these deals are probably drafted as such. They probably look great on paper. But the intent and the actions behind the parties aren't compliant. And in these arrangements, what you'll see is the form will say the physician's going to provide services to the company. So the physician's supposed to do work, track it, the time required, and submit the timesheets to be paid, on an hourly basis or on a monthly basis. And yet the substance behind it shows that either the physician didn't do any work or they were performing work that really wasn't necessary or even valuable to the company that was paying for it, and yet they still get paid. And so at the end of the day, the reality is that these physicians are really being paid as a way to reward them for their referrals or to pay them for referrals or to keep their referrals coming.
So our next two vocabulary words for the day are OIG and DOJ. And you don't really, if you're a healthcare provider, want to hear those words. Those are the enforcement bodies, the Office of Inspector General and the Department of Justice. So, Jay, these are all federal cases, right?
Right. These are all federal cases. And because the media, when they're talking about these issues, they're generally dealing with federal programs, Medicare, Medicaid, TRICARE. You only get involved in the state level issues when you're dealing outside of those federal type programs.
Yeah, and sometimes, what Jay and I will see is that many times the states will already have certain laws in place that are very similar, or they try to mimic the federal laws. And these arrangements you can run afoul even if you don't have federal payers involved. And so you could be violating your state laws. And further, as a licensed physician, you can be reported to your medical boards for violating a host of other rules, but typically the catch-all is you're violating professional or ethical obligations because you're participating in an arrangement where there's no substance to it. So, for example, Jay was talking about medical director. So if you're a medical director for a lab and you're paid for that and it says all these things you're going to do, but you've been absentee, meaning that you've never sat up and met with the staff. You've never actually been to the lab. You have no idea what equipment they're putting into the lab. All those are examples of you being an absentee physician, having no actual involvement, and even though you may have signed an actual medical director's agreement, that form doesn't match the substance and creates a giant compliance issue.
So I'd love to hear from both of you kind of for your takeaways. Let's, Jay, start with you.
Form must equal substance. I think that's as simple as we can put it. Brad and I say this all the time. We say this to every client we speak to when we're navigating these healthcare regulatory rules. We've even said it so much to certain clients that they'll repeat it to other people while we're in meetings with them because they know that we've ingrained it so much into them. And so when we're setting up these arrangements, we work hard to analyze every relationship involved, every person involved, to figure out, okay, what rules are we playing with, and then what steps do we have to do to be compliant? And it's a very detailed oriented process. And this compliance then is shown first and foremost in the documents that we as attorneys are going to prepare, meaning that on their face or the form, they're going to be developed to meet the regulatory requirements. They're going to say what you're supposed to do. They're going to be doing the compensation the way that you're supposed to be doing it. So the form is going to be compliant. But that's only part of the equation at the end of the day. To truly be compliant, the actual operations, the way people do business, the substance, that has to follow the same rules. And so we always say form must equal substance.
And even though Jay is the smartest guy in our firm, you would hope that form and substance that Jay is talking about, that you don't have to be the smartest guy in a firm to absolutely understand that. Because the minute the form and substance are different, it invites scrutiny from lots of investors. It invites scrutiny from your employees, and it invites scrutiny from the government. And so you can't assume that just because your document's great and it has all you've dotted all the I's and you crossed all the T's. Jay's the discussion of understanding the details of how you're operating the entity is actually almost more important than making sure all your I's and T's are crossed inside of an actual document. And so that's why it's so important that the form and substance must equal each other.
And to wrap it up, the correct legal documents are critical to a healthcare arrangement. The government wants to see the correct legal documents and that you're actually doing what the documents say. So if we go back to our story about the paid actors in Japan, the pictures on social media make people appear that they have a spouse and friends and a family. Well, similarly, the correct legal documents make you appear that you have the correct legal healthcare arrangement. If in actuality you don't have a family and friends and spouse and you're paying actors, you're going to feel a little sad. Well, in a healthcare deal, if you don't actually do what you say you're going to do, you're going to feel even more sad because you may be in jail.
Thanks again for joining us today. And remember, if you like this episode, please subscribe, make sure to give us a 5-star rating, and share with your friends.
You can also sign up for the ByrdAdatto newsletter by going to our website at ByrdAdatto.com.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.